Hi, this is Alan Gassman, and I'm here today with Christopher Wright, and he is right. It's really important to get the engagement letter and the relationship with a new client or even an existing client underway and squared away. So, Chris has been generous enough to actually share one of his favorite fee agreements and to talk to us about this whole thing, the importance of setting up the right relationship in many ways. As a reminder, this presentation does not qualify for continuing education credit. You're here because you want to learn, not because you need the credit. Um, we have estate view master classes, whether you're a subscriber or not, you might be interested in them. Monday, Wednesdays, Fridays at noon, Peter Farrell conducts them, so please feel free to join us. And let's talk a little bit about Christopher. He is a fantastic lawyer. He was a financial analyst and a CPA for almost 2 decades before he went to law school. He's a numbers guy, but he's also a people person. He is a law professor. He teaches estate and gift tax at the Catholic University of America, Columbus School of Law, and of course has his JD and also that business and accounting degree and background. So Chris, welcome, and tell us what your biggest passion is about the practice of law.
Thanks, Alan. Yeah, it's nice to meet you, everyone, and thanks for that introduction. I think my biggest passion with respect to the practice of law is the ability to help people navigate this complex topic and to help them set their mind at ease. The clients who come to us are ones who, first of all, have accepted the fact that at one day they will no longer be here, and they're looking for that guidance that the people that they love will be taken care of, and I like giving them that peace of mind.
That's fantastic. So Chris, I'm here on your background slide, and then we're going to move the slide control over to you so you can get started, and I'm seat belted and ready to go.
Okay, great. Okay, so as Alan said, I'm a CPA and an attorney, and what I will go through today is sort of been heavily influenced by my time as a CPA. When I first started practicing law, there were some engagement letters out there, but I found that they really were lacking for my taste. When you're a CPA and you give a client an engagement letter, it generally covers a very detailed section of what you're going to do, what you're not going to do, when you're going to do it, what the client can expect, and what the price is going to be. I think maybe there's just more oversight into what CPAs do. But so where those experiences have impacted me, I will go into it. Just as a disclaimer, this is what works for me. There's no real, really the only right way to do it is to make sure that you satisfy the rules of professional conduct. That's your background here. And I have not put all of the rules that can come to bear on an engagement letter, but these are the ones that I think apply to estate planners in more significantly. The scope of representation, what it is you're going to do for the client, what you're not going to do, how are you going to communicate with the client and keep them informed, what you're going to charge them. Your fees, of course, have to be reasonable. Confidentiality considerations, particularly in the area of estate planning where you have extended family members and financial advisors and accountants who want to be involved in the process. How does confidentiality play a role in that? And then, of course, conflicts of interest with respect to joint representation, which can be quite common when you have spouses. The other area that affects your engagement letter is going to be just contract law. Sometimes, for most of the time, your engagement agreement will be treated as a contract. If you could commit malpractice, that's a tort, but breach of contract is another claim that could be brought against you if you're not careful. So just some basic contract law concepts. There has to be offer and acceptance, meeting of the minds. It has to be definite enough. There has to be consideration, and of course your client has to have the capacity to enter into a contract. So as if you practice law enough in the area of estate planning, you will eventually come across someone who may have varying degrees of capacity, which you might have to consider too. So this is the roadmap for my engagement letter. So I have an opening paragraph where I identify the client. Then I talk about firm responsibilities, client responsibilities, fees and payment, modification and termination, and then some of my contract boilerplate. And really the reason that I spend so much time on the upfront process and this engagement letter is because people who get what they expect and at the price they expect to pay and on the timeline that they're expecting are rarely upset. They're usually very happy, and they will tell other people that it was an enjoyable experience. For most of my clients, the estate planning process is the only time they've ever even talked to a lawyer. They're used to going to the doctor. They understand when they go to a doctor's office, they're going to sign a contract that says they're going to pay. They're used to making payments. They're used to that doctor process, but they don't know how lawyers work. So I try to spend a lot of time going over this part of it. Okay, so opening paragraph in my engagement letter is to identify the client. And through each of my slides, I'll have snippets of my engagement letter, but all of this is in the full engagement letter that I've provided. So who is your client? That is always the number one concern when you're practicing law. Usually it's almost all the time, it's going to be the person who is signing the estate planning documents. So if you're not sure who your client is when you're meeting with people, then you need to make that very clear. Oftentimes you might have family members come to the first meeting where you might have two parents and a child or a sibling, and if they're all in the room at the same time, you have to make very clear who your client is and then follow that up with the engagement letter. You also at that time can address joint representation issues, which involve conflicts, confidentiality, and informed consent. When you're representing spouses jointly, what I always remind them is that, yes, it's confidentiality, but it's confidential between the three of us. I cannot keep secrets, and I cannot advocate for one person's position over the other. And if an actual conflict does arise, you will have to withdraw. So I always emphasize that with my clients right up front. And the example that I like to give them is don't call me up one day and start the conversation with, "Don't tell my spouse, but." I go, that's you will not get much further in the conversation if I hear those words. Scope of services. This is really up to you. You have to decide whether you want a general statement about your scope of services, whether you want to have a more detailed statement about your scope of services, whether you want to place limitations on the scope of services. So I've just highlighted a couple things here in my engagement letter. What I like to do is say that I'm going to give someone estate planning advice, which includes preparing documents. And I'd say that what I'm going to prepare is going to be based on information that they have provided to me. So I like them to read that and understand that this is the beginning of a collaborative process. The other thing I like to do is sort of tell them what I'm not going to do. And I've put up here a paragraph about funding a revocable trust. And this is really depends on how you like to practice law, whether you would use a paragraph like this. But I like to make clear that generally the fees estimate that I've given them may or may not include some other items, and that these engagements can always evolve into greater things. But those greater things would require a different engagement letter. And I do like to avoid phrases like otherwise agreed in writing, because you can easily find yourself on the hook for doing things that you didn't realize you were on the hook for, especially with the way that we communicate so quickly and fastly with email these days. Client might say, hey, can you do this? And we're like, oh yeah, sure, we can do that. And then it falls off your radar or you don't do it correctly. So I think this is the first opportunity for the client to really understand what it is you're doing. I also like to address the end of representation. Again, this is something that's personal to me, meaning personal in the sense that this is the way I like to practice law. I like to make clients know that when we're done, that I will not be your attorney after we're done, and that if you want to re-engage me, you can. Some attorneys like to keep that attorney-client relationship open forever, and that's fine. Some people love to practice law that way. For me, I look at estate planning as this is a project that has a fixed beginning and a fixed end. So I like to make clients aware of that, and that I also say that I'm not going to have a duty to continue to update you. And that is particularly, that does sort of come from the CPA side. When you do tax work, the tax laws are constantly changing. They're probably going to change during this webinar. And so what I like to tell people is, look, I do not have any continuing duty to update you. So it doesn't mean I won't. It just means I don't have a duty. I just don't want that duty. Timelines. Okay, so when are you going to give it to me, right? When can I expect the documents? And for me, I just know based on my workload, the number of clients I have in the pipeline, my staff that I have right now, I know that I can generally deliver drafts within about 4 weeks. So that has always been a comfortable timeline for me to tell them that I can deliver drafts to them. I don't always hit it, but when I don't hit it, I notify them and say, hey, we're not finished yet, but this is when it's going to happen. Because again, this is called communicating with your client and keeping them informed about the status of their matter. And so you have to do that. It doesn't ever bother me to let a client know that I'm going to be later than I told them. What matters is that you tell them. People don't want to be, they don't like radio silence. So you have to communicate with people. The other thing that in my practice, I don't do emergency legal services. So that is not what I do. If you come to me on December 15th and you want to make a huge gift, that's not my practice area. That might be another attorney who likes to do that type of last minute work and will charge accordingly and can do it competently. But for me, that is not my area. However, I do say in my fee agreement that if I'm made aware of a terminal illness, then I will try to expedite the drafts. But aside from that, I stick to my timelines. Okay, so now we are on to the part of my engagement letter where I'm looking at client responsibilities. And I like to make clients aware that they have responsibilities as part of this engagement. Again, going back to what I said earlier, where this may be the only time that these clients have ever talked to an attorney. They don't know what they're supposed to do. And so it's okay if you tell them this is what you are supposed to do during this engagement. And this also, if you read a lot of CPA engagement letters, particularly for tax return preparation services, there is a big section on client responsibilities. And so it just came natural to me to have that part in my documents. One of the client's responsibilities, in my mind, or for me in my practice of law, is to keep the originals. I do not escrow originals. I don't store originals. It's fine if you do. But what I make sure the client knows, you are going to get these documents at the end, and it is up to you to keep them safe forever. It's not, that's part of the estate plan. If you need to probate an original will, you're going to have to keep that original until you die. And I don't think it's that daunting of a task for a client. I set their mind at ease and I just say, look, you've managed to keep your original birth certificate this long. I think you can keep an original will the same way. And so I make sure they understand that's their responsibility. The other part that I make them aware of is with respect to beneficiary designations. And really, this is really the area of what we call will substitutes. So many assets these days have these non-probate transfers, and they all involve filling out a form, filling it out correctly, and then making sure it gets filed with the financial institution and that it's received. And I want to make them aware from the very beginning that there's probably going to be work for them to do. You know, I can fill out the form for them, but I can't file it for them. You know, they have to make sure the work gets done. And so that is something that I want the client to know that is their job. It's like if you go to a doctor and the doctor gives you physical therapy for 6 weeks, that's their job. That's your job, is to go get physical therapy, right? And to stick to it. So when I talk to a client, I let them know this is something you have to do. And I will answer as many questions as they want about how to fill out these forms, but I'm not going to take responsibility for making sure they actually get filed. But again, that's me. You guys out there, if you like to do that and you want to do that yourself, this is not a right or wrong situation. This is just making sure that they understand what the role of what my role is and what their role is. Document review. They have to read it. They have to read the documents, or at least try. Okay, I mean, give it your best shot. I understand that people start from the premise that, well, I don't understand all this legalese. But I think modern day estate plan drafting tries to use uh, modern day English. I mean, of course, we're still going to use terms like per stirpes and all of that other great Latin, but I can explain that to them in about 10 seconds. But the rest of it, they have to read, and they should be able to understand what they're reading. And what I like to do is say, if you see something that you think is a mistake, let me know. Don't assume, well, he's the attorney, he must know what he's doing. Don't Make sure your client knows that it's okay for them to let you know if they think there is a mistake. Um, and this also kind of comes back to my days as a CPA, preparing a tax return and sending it to someone, say, hey, you need to review this. And if you see something that looks wrong, you need to let me know. And so I do want the client to know that this is part of their job, that this is a collaborative effort, that they are expected to cooperate with me. They're expected to be available to me to answer questions, that they're going to provide me with the information that I need to do the work that they hired me to do. And I have no problem using this as a reason for withdrawing from an engagement. I was at an ethics CLE several years ago. My malpractice carrier does a 2-hour free CLE up here in Virginia every year, and one attendee from the crowd asked one of the ethics counsel, well, what happens if your client just won't schedule a meeting to review the documents, won't schedule a meeting to sign the documents? What do I do? And he said, withdraw. Withdraw. You cannot let your clients hang out there with unsigned drafts, not getting back to you, because when something goes wrong and they need it immediately, or if they pass away in the interim, not that you will be on the hook for malpractice, that's not the issue. But while these drafts are unsigned and things aren't moving forward, you are at risk. And so that's all we're talking about here, is really eliminating risk. And usually, I don't have to withdraw. I just have to tell the client, hey, if I don't hear from you, I'm going to withdraw. And then they get in line. Okay, it's not that hard to follow up with them. Okay, financial information. We rely heavily on our clients self-reporting to us what they own, how they own it, and the amount. And it was astonishing to me to learn that attorneys just take people's word for it. Because as a CPA, when you never take your client's word for it, almost never. You have to use some sort of independent judgment or some due diligence. And of course, the whole point of an audit is not taking their word for it. And so I wanted the client to know that I'm relying on what they tell me, and that I'm not going to conduct my own independent verification unless they want me to do it. But I want them to know that it's very important. Now, some attorneys will do this anyway, but that's up to them. Of course, when it comes to deed work and that sort of thing, of course, I'm going to pull the deed. But one thing I don't ask for is, for example, would be copies of their bank statements to verify the amount. I'm gonna rely on them for the amounts. And it's really okay if you want to do all of the work to verify the information. I would just want you to, my point is, bring this up in the engagement letter and decide who's going to be responsible for it. Because, of course, if the information is wrong, the plan could be wrong, or it might not go the way that you're expecting it to go.
Chris, what percentage of the time would you say the client reads the engagement letter carefully and asks you questions about it to renegotiate?
Up here in the DC area, I mean, where everyone is either an attorney or a contractor, I think my engagement letter gets read quite a bit. But I would say even with those statistics, I would say less than half. Less than half. I've had uh, I've had attorneys up here read engagement letters, and they will come back to me with edits. But
And what do they object to the most?
mostly they want to understand. Sometimes there's confusion on the estimate. They want to make sure that they understand how much they're going to pay. That is usually the part that's confusing. With the rest of my engagement letter, though, I've tried not to use words that they were like defined terms that you might see in a contract. I'm trying not to use words that have multiple meanings and that sort of thing, but it's usually this slide right here about fees and payments.
Thank you.
As an attorney, our fees must be reasonable. You'll get no more guidance than that from the rules of ethics. And there are a number of ways that you can structure your fee agreements. For a long time, I did a fixed fee agreement, but then I decided to go to hourly because I just could not predict the way the engagement was going to go. It was just too difficult. Because one thing I know is in almost 15 years of practicing law as an estate planning attorney, believe it or not, I've never had one client who says, I have a complex estate plan. Everyone believes their estate plan is simple, and it's not going to be complex. So I learned quickly that everyone believes their plan is simple. And it may end up being simple, but I don't know what's going to happen. So I went to an hourly structure after that. And so I start out by letting them know that we're going to have an hourly fee agreement. I put my rate in there as well as the rates of everyone else on my staff. That way, when they're reviewing the invoice, they can match up the rates with the fee agreement if they so choose. And I do have I would say maybe 25% of my clients up here are used to reviewing invoices, and they do match up the rates. Deposits, I get a deposit. I get a deposit as large as I can. And I'm happy to put it in I explain trust accounts to clients. I explain how that works because that's, again, unusual for people who have not had lawyers before is what happens to the money I give to them. This is very important with respect to ethics. Trust account violations are probably the biggest reason that lawyers are disciplined. So I let them know that we are going to collect the deposit, and then I'm going to bill my time against it. And when the deposit is exhausted, then I will ask for more money. That's how that works. Again, deposits are kind of up to the way you like to practice law, but I also use my deposit. This is how I, in one way, weed out clients that really don't need me. Because if I tell someone that I need a $10,000 deposit, we learn real quick how serious they are about getting the work that I'm going to provide. Because depending on how you receive your clients, you depending on how good you are at knowing based on a 30-minute conversation whether that's the type of client you want. I'm getting better at it, at talking to clients and trying to figure out in a 15-minute conversation if they're going to cooperate with me, if they're going to be easy to deal with. But the one thing that does help is the fee. If I say, hey, I need a $5,000 deposit or a $10,000 deposit, that helps narrow the field for me. And of course, I make it clear that I'm going to give back what it is is left over. Now, of course, my deposits aren't outrageous. I mean, they're not going to ask for more than what I expect with 100% of the fee, but I like to get it up front. You know, as one of my mentors said, Chris, if they don't have $5,000 today, they will not have it in 30 days. So that's where that comes in. Okay, estimates and invoicing. So I do give estimates. Some of the larger estates, maybe you probably can't give out an estimate, which if it's that big of an estate, the client probably doesn't need an estimate. But maybe for your average engagements, you should be able to give an estimate. How invoices? I'm going to send you an invoice and you need to pay it. And you'll need to pay it when I send it to you. This is not a net 30, net 60 agreement. And again, that was something that when I was an accountant doing accounts receivable, and I would understand invoicing. So when I came to the practice of law, I said, okay, the client needs to know they're going to get an invoice. They need to know how they're going to receive the invoice and when they're expected to pay it by. I have in my fee agreement, what happens if they don't pay. Frankly, I've never charged anyone interest. I probably never will. But that, and again, you have to check with your rules of ethics in the state that you practice whether that's even allowed. But that's something that you could consider. On the estimate side, I do have after practicing law for several years, I had a good amount of data on how many hours it took me to do a particular type of an estate plan. I knew how many hours it took to onboard the client. I knew how many hours it took to prepare the drafts. I knew how many hours it took my paralegal to follow up with the client to schedule a review session. I had all of that data. And so I created just a simple spreadsheet to try and calculate what each type of an estate plan would cost. And that's what I use for my estimates. But I let them know in my fee agreement that it's just based on my past experience, and these things could change. They might be higher, might be lower. Okay, this is another ethics issue, third-party payments. It comes up under the conflict of interest rules, under Rule 1.8, paragraph F, where it says a lawyer shall not accept compensation for representing a client from one other than the client. And then you have the unless. So where will this come up? Most likely it'll come up with a parent who wants to pay for their child's estate plan. That's when it'll come up. I put a bullet point there because it came up. It comes up for me in divorce settlements where one client is getting their estate plan paid for by the ex-spouse. And that's sticky because, of course, the ex who's paying for the plan wants to know all about it and why it costs so much. So you have to be aware of these rules of ethics that are out there if you're going to get paid from someone other than your client. And these aren't, this is not something that's in the engagement letter that I provided. This is just a template that I have on the side that I can swap in if that happens. So now I get to the part of my engagement letter where I call contract boilerplate. And this is the part where I try not to, where you can get long run-on sentences with your boilerplate, but I believe it's very important. You don't want to have an engagement letter that's so complicated that they should get another lawyer to read it. That's not the object here. But the object is, I think you do have to address some minimum things. I think you have to address, emailing documents, what email to use. Some clients get very used to using their work email address, and that's not a good idea to use a work email address because generally they don't own that email. So this is just something to bring to their attention. Talk about using client portals and exchanging documents that way. I think this is something that you can go over with the client in the first meeting, but it can also be in your engagement letter. I also talk to clients about how they can end the agreement if they don't want to proceed or they've decided for some reason that they don't like the way things are going. I have not had that issue, thankfully, because anytime anything comes up, I do work very hard to make sure clients are happy. And if something happens where they misunderstand, most of the time, if there is a misunderstanding, it could be on the fee side. It could also be that even after you spent a lot of time educating the client on the documents you're going to draft and what the purpose of each document is, they may not fully get it. And then all of a sudden the light bulb goes on and they want to pivot to something, to a different type of service. Meaning, let's say you're just doing a plan and there's no trust involved, and then all of a sudden it dawns on them what a will is for, and then they want to change the engagement. So that allows them to do it, of course, and they don't need a reason to terminate a service with an attorney. If they want to terminate it at any time without much notice. I always love the phrase with or without notice. I don't know how you would terminate without notice, but you see that all over the place. I think you have to have some notice. Otherwise, you wouldn't know that it ended. But That's what this part is for. Fee disputes, we like to address fee disputes in our engagement letters. You don't have to. I rarely have a fee dispute, but if I do, I'm pretty much there to disarm the client and just say, I don't need to create an unhappy client for a few $1,000s. It's really just not worth it for me. And so I'm pretty generous when it comes to fee disputes. Again, setting expectations, getting a good deposit will go a long way to eliminating fee disputes, but they still happen. Someone is like, oh man, I didn't know it was going to cost this much or whatever. Look, if you're doing estate planning, you're probably doing, I don't want to call it a high volume business, but it's a volume business. You're probably doing quite a few of them. And so, who has time for a bar complaint for a couple of $1,000s? I mean, I don't. It's just not worth it. I have a paragraph on confidentiality, which allows me to involve family members and advisors if needed. You have to be very careful of the rules of confidentiality when it comes to talking with other advisors and other family members. I think you have to explain why the rules of confidentiality exist, and you have to make them understand what happens if they're waiving it. And then I think you need to get it in writing. So this is a paragraph that I can put in my engagement letter, where I can have the client waive confidentiality. Okay, miscellaneous terms governing law. That's again, this is going to be a contract, and even if you don't say that it's a contract, you have the rules of ethics that apply. We have 50 states, 50 sets of rules of ethics. So I just say that in my engagement letter, I say Virginia law governs this contract, and the Virginia rules of ethics are a part of this, because I'm not an expert in the nuances of ethics, and I would not intentionally violate them. But if I have something in my engagement letter that does inadvertently violates the ethics, I just throw it. I say, hey, that won't apply. I have their typical integration clause. Hey, everything that we've talked about is in this letter. I don't have too many. I have not really had the opportunity yet to prepare an estate plan based on an agent's authority under a power of attorney. But I believe that's going to happen. We see cases all the time about agents that don't have the authority to amend a revocable trust. If you have an agent, the agent should represent to you that they have the authority to act on behalf of the principal. No warranties on outcomes. I'm planning. I'm creating a plan that someone is going to have to execute someday. I can draft the greatest Q-tip trust that the attorneys on this call can produce. But we know unless someone files the 706 and makes an election, there will be no marital deduction. So there are outcomes that I cannot control in what I do. Electronic signatures. All of my documents are signed electronically. We send them out through. We use Clio. That's our time and billing system, and you can get electronic signatures that way. I address work papers, document retention policies, third-party beneficiaries. You could do a whole 1 hour CLE on standing to sue an attorney for malpractice under the theory of third-party beneficiaries. Those laws are various throughout the states. I added a third-party beneficiary clause to my engagement letter quite some time ago. And it's you have to look at the law in your state to see if you would be liable to a beneficiary for malpractice under a third-party beneficiary rule, and if you can avoid it through adding this clause in your agreement, that's why I put it there. Finally, you also have these joint representation issues where you have to really, I probably should have made that a slide by itself. It is clearly not a miscellaneous term. But with joint representation issues, there's a lot that gets involved, and you need to. I have a very long paragraph in my engagement letter about that, and you have to address this with spouses so that they understand what your role is, and that they are agreeing to this type of representation. And with that, I think we've got like 13 minutes for questions, comments, anything else, Alan?
Yeah, we've got some nice questions here, and we appreciate all questions. So the first question is, if you had to withdraw from an engagement, what kind of language would you use? And would you give explanations or reasons for withdrawing? How has that normally worked for you?
Well, if I'm going to withdraw, I have to follow the rules of ethics regarding withdrawal of representation, and I have to make sure that the client, I have to look and see what kind of harm I might be causing to the client. But my withdrawal is going to be in writing, and I will explain to them why I'm withdrawing. If it's generally, it's going to be for lack of cooperation, that they haven't signed their documents, and I will let them down easy. It does not have to end in an adversarial manner. A lot of times, if someone just won't sign their documents, I let them know, hey, we've tried to schedule it, we can't. We're going to end our representation now. And at that point, usually the client will acknowledge, oh, this happened in my life and that happened in my life, and I can't do it right now. And I'll say, no problem. When you're ready, contact us. We will reestablish our attorney-client relationship, and then we can move forward there. And I let them know, just so you know, my fees may be different at that time. The law may be different at that time. So what I've drafted for you may be out of date. So I think those are the considerations that you have to think about when you withdraw.
Okay. The next question is, how does a CPA's engagement letter differ from an attorney's engagement letter?
Oh, well, it depends on it depends on what the CPA is going to do. I mean, a CPA, of course, can't practice law, but so most of the CPAs that you have, their engagement letters were prepared by an attorney who's looking to protect the CPA from all sorts of things. So one thing you'll see that I've seen in CPA letters that you will not find in my engagement letter is a limitation on liability. I don't believe lawyers can ethically limit their liability in an engagement letter. A CPA, on the other hand, uh, I've seen this in their engagement letters to prepare tax returns that says their liability is limited to the fee. I've seen that in a CPA. That's just one example, though.
Okay, that's very good. Do you typically have the engagement letter generated and review it in a consult with the client, or do you just send it to them?
I send it to them because I need to reflect on the meeting. Um, Alan, you had a webinar a couple months ago where you talked about, I didn't realize this. You said when the meeting is over, you stay in the same spot in the same chair, and you because your memory is better. And so I started doing that so that and immediately take notes about the conversation, because what I can do is that gives me time to reflect and make sure I don't want to change anything, because there's nothing in stone at that point, right? And the client isn't expecting uh, an engagement letter on the spot. So I have no problem. I do it later. I do it within a couple days, right? I try to do it as fast as possible, but I don't do it on the spot.
Okay. Yep. Are you finding that I was correct that when you sit where you sat when you were with the client, that it helped
Yes.
memory?
Yeah. Oh,
As a
it
matter of
helps so much because that little thing where you get up from the conference room and go back to your office, you're already thinking of something other than what you just did.
yeah, yeah. Just to repeat it, what I do is I call in the secretary or paralegal or lawyer who's helping me with this project, and I tell them the whole story right after I meet with the client. It may take 5 minutes, it may take 20 minutes. It's all recorded. I go through all my notes. And then while I'm doing that, things come to mind, or my colleague or secretary will say, well, didn't you ask them where they wanted to be buried? You forgot to ask them that? Don't you realize you should have asked them that? Oh, sorry. So it works out well. Okay, so the next question is, how do you work with financial advisors? Do you have them there at the first meeting? Are they involved with the fee agreement situation? How does that all work with you?
So that has to be initiated by the client. Even though I get quite a few referrals from financial advisors, that interaction with the financial advisor has to be initiated by the client. If the client wants their financial advisor involved, then I will explain to them what that entails. And then the other thing I'll ask them, well, what do you mean by how much involvement do you want, right? Because they may not understand that they have an option. Again, when I go back to, this may be one of the few times clients have interacted with an attorney. They may not understand they have an option to not have people there. So I just talk to them about that. But then once the client says no, I trust my financial advisor more than I trust my children. I want them to be involved in all this and to understand everything that's going on. So at that point, I'm happy to involve the financial advisor. At that point, I'm happy to get information from the financial advisor. I'm happy to involve the financial advisor in reviewing drafts and let the financial advisor ask questions and that sort of thing.
Okay, I wanted to show off something from Estate View, and everybody's welcome to get a free trial of Estate View, or I can send you this letter. But I have a letter writer uh, uh, application, and after that meeting, you might want to consider following Chris's advice with a separate letter that would get into more detail on the attorney-client privilege. So as you can see here on the left-hand side of my screen, this kind of forces you to think through, um, have I talked to the client about confidentiality and the attorney-client privilege in language that they can understand? Have I talked to them about the CPA privilege and the lack of a CPA privilege in bankruptcy or federal court? Have I talked about conflict of interest? And in particular, if I've talked about conflict of interest, am I going to recommend a marital type of agreement? Am I going to recommend that one or more of these clients get separate counsel? Am I going to remember to tell the billing department whose name to put on the bill? Because your fee agreement may say you're only representing Mr. Jones, but if your billing department flubs up and sends the bills to both of them, then you may be representing Mrs. Jones. And then I've got a box to check for joint representation issues. So, Chris, what comes to mind when you look at this and the design of provisions to go into a deeper dive on these issues?
Informed consent. Okay, that is a word you guys need to get comfortable with. Again, I go back to doctors. We all know doctors. You need informed consent. And if you don't communicate in, like Alan said, in a way the client can understand, then you really don't have a waiver, do you? I mean, you're at risk if you're not getting informed consent.
So you've got to be able to say, to be really safe, you've got to be able to say, I explained it.
Yes.
It wasn't only that they signed a letter or that they got an email, I actually explained it to them.
Yes, because if an issue arises, they're just going to say, well, I just signed it. I didn't really understand it.
And do you meet with the client alone or do you have a scribe with you, or are your clients allowing you to enable AI to document what you told them?
So there's a lot to unpack there. So the first thing is in the initial meeting, I'm meeting with the clients by myself, and then I have an associate attorney in there or my paralegal to help with note taking. Um, the the part about AI, I'm just learning about. I mean, I just learned about literally this week about AI and Zoom, and I'm trying to understand the ethics behind using that. But I see a future where I want to use that. Now, you do have to, you have to get the client's consent, right? You can't just put an iPhone next to your speaker and press record if your client doesn't know that. So that's most of the time in this. I know in Virginia that's an ethics violation. So you have to make sure your client consents and that they understand what they're consenting to. But I'm looking forward to being able to use that because I think that's going to be beneficial to myself and to the client.
Yeah. Our fee agreement has them check a box. Do you authorize us to use AI in Zoom calls and meetings to summarize the calls and meetings? And about 1/3 of them will check the box yes, about 1/3 will say no, and about 1/3 will check neither box, in which case we consider that to be a no.
Yeah, that's great. That's great. I like that idea.
Yeah, yeah. So, Chris, the hour's up. That went really fast. That was very practical. I certainly learned a lot about it. We'd love for you to come back sometime, and maybe it'll be just 10 or 15 minutes, maybe longer, to tell us about this process where you've measured the time and billing that would go into each category of project that you do. And then you put that on a spreadsheet so you know statistically what it's likely to cost in time and money so that you can give the client a realistic appraisal. I think that's brilliant, and I've never heard of it before.
Oh, sure. Yep. Absolutely. I'd love to.
Okay. All right. Fantastic. Well, for those of you who are Estate View subscribers or you're interested, I want to show you where we are with the intake program. And Chris, you're welcome to stay or welcome, if you need to
Thanks.
just.
Yeah, I'm going to stay. You can turn my camera off if you like, but I'm going to stay.
Okay. All right. So, anyway, if you want a free trial on Estate View, just go to estateview.link, put that in your browser, and then uh, go in as a new subscriber, and I can email you oh, here's your passcode, free trial. So just go in as a new subscriber and use the word free trial. It's one word. So I'm going to go into Estate View here, and I'm on the home page. And if you haven't used our AI, I'll just show it to you for a second. You can adjust the speed on the AI to fast and less detailed, or slow and more detailed. We don't charge anyone for the AI. Once you're a subscriber, right now we're not metering the AI or charging anyone for the volume of use. Then if you want to look at an estate or trust document or a buy-sell agreement, and soon we're adding tax returns and investment uh, account statements, then or you can try a sample document, cut and paste and copy. I'm sorry, just paste a document here or choose a document. It'll read the document, it'll analyze the document. If you haven't done that, do it with your own documents because it will improve your own documents, and it's darn interesting. So that's one thing. But when I go to Instant Plan, I can choose that I just want the calculator inputs or I want a full client intake. And so I click on full client intake right now, and I click on get started or view clients. If it's a new client or an old client, I can now click on view clients, and it will tell me the clients that I have already handled and stored so that I can pick up where I was. So if I want to go back to where I was with John and Mary, I can click on them and I can open their client data. And there's John and Mary. And then I fill in the client data. That's pretty much common sense. Or if you're just playing with it and you want to see how it works, you can click on replace inputs with sample data and confirm that. Oh, we added something just this morning. One of the interns came up with this. I thought it was pretty smart, interesting. So this says that Bob and Mary, while Bob is alive, will save $350,000 a year until he reaches age 70, and then they'll be spending $250,000 a year, and then at age 80 they'll be spending $200,000 a year. But as you've got a graph here now, which I thought was good. So I thought, Mason, thanks for that suggestion. Anyway, once I have all my data in, I can review a summary if I want to, or I can just click on results. And then once I click on results, I can now generate a summary chart for the client that is consistent with the chart that we've been using for years that, quite frankly, clients love. And I will just click on generate planning chart. And then I have four choices here for a married couple. I can show them without any mention of a living trust. I can show with mention of a joint living trust. And I can show them with mention of dual revocable trusts. And then I just open up that sample planning chart, and you can see that it lists all of their assets, what's under Bob as far as checking, IRAs, savings. There's a comprehensive summary there on the bottom left. I've got all of the advisors show up at the bottom left, and I've got Sorry, I'm magnifying. But I've got their entities, the value of the entities, the portions of the entities that they own, their joint assets, their individual assets, their life insurance, and then for both of them, a required minimum distribution summary of what we expect to have happen based on the minimum distribution rules under each of their IRAs, both with and without charity, showing the tax savings of doing qualified charitable deductions. And then I've got their relatives and their fiduciaries. And then I've got red flags. I'm still working on this, but this says, hey, your grandson is driving your car. Are you sure you want him to do that? And is he given powers of attorney to his parents? He's 18 now. And this parent you're going to inherit from. Shouldn't there be a trust set up for your inheritance? This one you're going to probably support. Should they go see a Medicaid lawyer? And your boat is more than 21 feet. Did you know you probably need an extra umbrella for that? So this is going to go on and on. It's going to say you have investment real estate under your name. Shouldn't it be under an LLC? You own 100% of an LLC. Shouldn't there be another member so you have charging order protection, et cetera, et cetera? Then I've got a family tree. So during the meeting, I can glance at this and not be embarrassed by the fact that I keep forgetting the client's name and who Jim Jr. is and Jim Sr. and who's Jimmy and who's Johnny and who's Jim. It's all here on the family tree. So that should help you a lot with your intake. And when you print this on 2 pages ledger size and just scotch tape them together, or we have a bigger printer than that, it's really nice when they walk in and they see that on the table. Or during my Zoom calls, I will show them the chart and I take my notes onto the chart while they're talking. So while they're talking, I'm saying IRA, I'm typing in IRA. Well, let me enable editing. So during the talk, I'm just saying this company will be closed next year. And then they talk about this company and they see me typing out, will go to Johnny on death. And they see how terrible of a typist I am, and that may amuse them. So that's one of those intake features that I think we've been doing that by hand until May when we got this working. Now we're not preparing them by hand. The second spreadsheet, I apologize for the phone call there, but I already have a timeshare. So the second spreadsheet that you can download gives you a different view of their assets. Let me see where it went. Where are you? Aha. Open, please. Well, let me print that again. I'm a little bit clumsy. All right. Where did it go? All right. Well, I'll show it to you next time. It must be behind something. Anyway, then I've got the family tree, which I showed you. Then I've got a calendar of everybody's birthday and anniversary. And those of us who are males probably don't have a nice calendar to remind us of everybody's birthday and anniversary. Then I have my Monte Carlo results showing them the possibility by percentile of growth rates and how this $4 million portfolio might be worth $15 million in 31 years or $200 million if it's the top one or top lowest percentile, etc. And then I have my married couple comprehensive showing them their estate tax with and without each of the primary planning modes. And I've got the letter writer. So now that letter I was just showing you automatically spits out, and then you could just put it on screen as a Word document and you can edit it if you want to. And then I've got a point of discussion memo. And that point of discussion memo is all those red flags that you saw. So this is a good reminder. You know, you walk out of a meeting and you go, oh, I forgot to tell them that they ought to have their gun silencer in a gun trust so that everyone in the family can use it. Well, now at least I'm going to have something in writing that I can hand them. I can hand them and say, this was computer generated. I wouldn't rely on it, but you might find it to be a good checklist. The other thing it does also, by the way, is for each item, it says, hey, your life insurance policy you might want to put it in a life insurance trust. Talk to your life insurance agent about that. Talk to your CPA about it. Here's a reminder of who they are, what their email addresses are, and what their phone numbers are. So we're having a lot of fun with it. Most of you on this webinar are subscribers, so I don't want to put you to sleep by telling you too much, but those are our most recent improvements. Oh, I'm going to go back to Instant Plan. Go ahead and check this out. So I can get started. I can put all the data in, and then I can send it to the client. So I click on Send Portal Link, and then I can send my questionnaire to somebody, whoever I want to send it to. I've put the client's email address in. It emails to the client. The client fills out the form as much as or little as they want. Then they click something to send it back to me. Then once I receive it, I click on results. Now, a big question is, what about privacy? And I will say that the Amazon cloud system that allows software developers like us to push the program onto your computer. See, when you use Estate View, everything is on your computer. Your data, your questions, your information is only on your computer, and it's on your browser, or you can choose to save it. So once you save it, it's on your computer. It never hits the Amazon cloud. So we don't have it. We can't see it. And that's really neat. Also, with our artificial intelligence, the Amazon cloud and the AI company have an arrangement where we don't see the inquiry and the AI world doesn't see the inquiry. It happens within that cloud on your computer, which is why it's so slow. So when you're doing this type of stuff with software, you want to make sure that it is what they call SOC 2 certified, and that there has been penetration testing by a reputable penetration testing company, and they'll make sure that everything stays private. So anyway, that's our program for today. I again want to sincerely thank Chris Wright. I thought he did a fantastic job on that presentation. Lots of really good reminders of what we need to do and what we need to know when we get ready to help a client. Let me see if there were any other. Thank you, Matt, for enjoying the presentation. Thank you, Diane, for enjoying the presentation. And if anyone would like for us to send you our fillable PDF form, and then we'll run an estate plan for free with you on Estate View if you send us the filled out form, please feel free. We'll be glad to provide it to you. You might even ask AI to take your data and put it into our fillable PDF form on your computer. Have a great rest of your weekend. Thanks for hanging with us. Bye.